Here we go. Got it.
Perfect.
Yes.
Hey, good morning, everyone. I'm Chris Parker. This is Chris Nishihara with the Ishihara and Parker Law Firm here in Longview, Texas. And today we have more of a nuts and bolts kind of situation. We're in a situation where someone has came in. They've already created a revocable living trust. If you don't know what that is, you're not sure, please look back at the other videos. But you've done it. Are those folks who come in and see the attorney, sign the revocable trust, and they pat themselves on the back because they're done? Or is there more things we need to do, Kristen?
Sure. So with a revocable living trust, the most important thing you need to do is actually fund the trust. So if you have an attorney setting this up for you, you should be discussing that with the attorney, but there are most of the things you actually have to do to fund the trust. So when we send a client out of here, we send them with some written homework. Here's the things that you need to go do to accomplish getting this into the trust. On most trusts, you'll find a schedule that may or may not list what's in the trust, but that does not put things in the trust. Yep. So it really doesn't help you except for maybe identifying if somebody needed to pick it up and see what they thought was in the trust. But I actually find it confusing. So to move things into the trust, there has to be a legal transfer of title into the trust to make that happen. It's not enough to write it down on a schedule. It's not enough to send a letter saying you want the beneficiary to be updated to be that. We've seen funding done in a number of different ways. If you have not actually legally moved it, transfer title into the trust, you've not accomplished what you set out to accomplish. So super fun.
Yeah, let me be clear. So I have people come in and say, here's my revocable trust. The very first item, action item says that this bank account goes to Sally, right? It'll say, number one, bank account goes to Sally. And they think that's it. They wrote it in the trust. It's done. And they don't understand that if someone doesn't physically go take that step to put it into the trust, then what's written in the trust isn't very helpful.
Right. And I usually try to think of it like a bucket, so your trust is going to own things the same way you own things as an individual, the same way that if you had an LLC, that business would own things. Think of the trust like a bucket that you need to get things into so that it actually owns it. And then that's how the trust helps you, because the trust terms will control who manages it, where it goes in the event of your incapacity or your death. So the whole plan that you created that was very important doesn't really help you any if you've not gotten things in it. So we just want to talk about how to fund it, the importance of funding it. So what's first on our list that we need to fund with?
I think for most people, it's your home, right? They come in, it's usually your biggest single asset. You have a home, it's either paid for, has a note, it and the attached property need to go into the trust, which the attorney, I would presume, normally does for you. It's what we do. We look it up the appraisal district, we find the deed records, we find the deed, we type it up, and then you as grantor and trustee are deeding it to yourself as trustee of the trust.
Sure. Really, with a revocable trust, remember that you still own it and control it. And typically you're the trustee, so you're still going to manage it. That's not true in all cases, but often that's true. So for the most part, now Chris and I never give rules that apply to everybody all the time, right? You still need an individualized review with either us or another attorney that specializes in this. But for the most part, you would recommend that all real property that you own, all land, all minerals, all real property that you own actually get moved into the trust. That's super important if you have out-of-state real property, because it will help you avoid probating where you pass away in Texas and then reprobating. You're, of course, not doing this. This is your kids or executor having to probate a second time in another state. So very important that if you have land or real property, that gets correctly into the trust.
I've seen some clients express concern that they will, when it comes to their home, they lose their homestead exemptions. Mm-hmm. Is that a problem?
No. So with a revocable trust, again, remember that it is you that actually owns the trust. So the trust will have the correct, or should have the correct, qualifying trust language, which in Texas, the tax appraisal requires that you are able to live rent-free in your own home. Kind of a silly requirement, but it is in there and needs to be in your trust. And then also that it remains still yours, so you can homestead it, you keep all your property tax exemptions or freezes, so nothing should really change. Now, one thing that does happen is if you have land or other exemptions, maybe you have a timber exemption that you've gone through, or you have an ag exemption, something you've gone through with the tax appraisal office, that may have to be redone. You may have to re-sign or recertify those things because technically the land has been moved to be owned by you as trustee of your trust. So while all the provisions can remain the same, you might need to go re-sign something with the tax appraisal office.
All right, so we took care of our home. We took care of our in-state land. We definitely took care of our out-of-state land. What's the next biggest asset most people look at? What do you do after land? What's the one you look at?
Well, sure. So you have to move in all financial accounts. So that would be certainly your bank accounts need to be retitled into the trust. Most banks will allow you because it is still, again, a grantor trust. It is still your social security number. There's not typically a new tax ID number. You're still operating under your social or your spouse's social security number. So a lot of banks will allow you with what's called a certificate or certification of trust. When you go in there and give that to them, they will retitle the signature card on an existing account to be in your trust. Now, we can't speak for all banks. That's not true of all banks, but a lot of them will allow you to do that.
And I know our out-of-state friends, their documents will be slightly different, but here in Texas, the certificate of trust, that's the actual document that says, hey, this person is the current trustee of the trust. This person's able to make decisions such as putting in or removing assets from the trust.
Right. So on your funding list, you would want to have all bank accounts. The benefit of that is, of course, if you're going to use the trust, if you're going to pay to set up a trust, you should use it to the full extent that it can help you. And when you have a bank account in the trust, if you become incapacitated, your successor trustee has access by signing a new certificate and going through the process. When you pass away, the trustee has access because they step up as the successor trustee. So everything that is in the trust is much more immediately available to them than it would be if you were going through the probate process.
All right, we've gone through our local checking, savings, maybe our local CDs, that kind of thing. What's next level up? What are the next things that we look at for trust funding?
So, of course, any financial account is going to include also any financial advisor or brokerage accounts you have. But we need to make a distinction between retirement, IRA, 401k, things that went in before they were taxed versus things that are after tax or taxable accounts. So we want you to move in any non-retirement accounts into the trust. So that's investment accounts, that's savings accounts, that's brokerage accounts, TOD accounts, a number of different names for them. But if you paid tax on it when you earned it, or maybe you inherited it, but now when it grows, it's taxable to you, then that really should be retitled into the trust.
All right, we take care of the financial institutions. We have questions, we call our advisor. We work it out with them to make sure that's all done. So we've handled the home, the land, the out-of-state property. We've handled the investments and the local banking. What's the next asset or assets we should be looking at?
Yeah, so you might assign certain things to the trust. That could be personal property, tangible personal property you typically want to assign to the trust. And then you also might assign some business ownership interests. So if I own a business, that LLC or however that's set up or structured, that might be something that I want to assign to the trust for management. So especially that allows for management in the event of my incapacity or death, but then also transitions that asset upon my death. But there are some things that we would pull out of that, Chris. What's an example of something we might not assign or might not put into the trust that we talk about?
Well, I mean, we already mentioned qualified accounts. I wouldn't put those in there. Sometimes my clients have questions about life insurance.
Yeah.
Sometimes my clients have questions about vehicles.
Okay. What would you say?
Generally speaking, I'm not going to put the vehicle into the trust. Now, sometimes there's people who have super expensive vehicles that they want to, though there can be some issues I've had in the past with them trying to tax that transfer that I don't think it's supposed to. Other times it's a disposition. If it's going to all the kids equally, then I'm not so worried about putting the vehicle in the trust. If instead it's going to one child, you might want to consider it. But to me, the reason I don't like to put vehicles into the trust is I feel like if you get in a car wreck, what's the very first thing they're going to see? That a vehicle owned by someone's in a trust got in a wreck. It just makes me worried about the trust protection when I have a vehicle in a wreck. And you're switching vehicles all the time, and I don't know. Vehicles make me nervous.
Sure. And vehicles also have the option now in Texas of adding a beneficiary on them. Yeah. So a lot of times that's the way that it might still be on your funding homework, not to move it into the trust, but to set up for it to have a designated beneficiary on the actual title. And that will transition that asset, not through the trust, but to the beneficiary that you want it to go to. Same thing for IRAs and life insurance. Sometimes we talk about not having them owned by the trust, but making sure that your beneficiaries are correctly updated. Depends on your plan. So retirement, we would not be able to answer one specific rule for everybody. But the IRA, because it has taxable consequences, and when you are now sending it to kids, the Secure Act gives them 10 years to pull it out. A lot of times we end up having people just list their spouse first, then their backup beneficiaries if they're all adults and that's appropriate, rather than including the trust as a beneficiary. And life insurance is going to be often an individualized assessment, whether it makes sense to include the trust as a beneficiary or to just list individuals.
Honestly, I usually list it as the last asset for people to consider because by the time they get down to there, they're pretty frustrated and tired. And at least in my experience, the life insurance companies are pretty good about paying out in a timely manner upon presentation of the death certificate, and their beneficiary forms are usually up to date. So, it's all a matter of experiences, but of the things that my clients may have not funded, the life insurance is usually the safest one for them to have skipped. I'm not saying do that. I'm just saying.
Yeah. Again, all of our advice is going to be specific to you as an individual, but you do need to run through all of these assets and make sure that either you've gotten them into the trust so you understand what's going to happen, or you've set them up in some other way and you understand that they're not going to be in the trust. They're going to pass through that other direction.
Okay. So I see the attorney. I come in, I meet with you, Kristen. I've followed the list you've made. I've done a great job, and I pat myself on the back, and I put this thing up, and I shelve it for the next 5 years. But in that 5 years, of course, my Aunt Sarah passed away, and she left me money, and then I forget about it. Was I supposed to do something with later acquired assets?
Sure. So the importance of the trust includes funding with future assets. So if I go out and buy a lake house, I should hopefully remember to put it in the trust when I purchase it. If I don't, you can always move it in. So with a revocable trust, since it's all yours, there's no timing, there's nothing that's important. We just want to keep stuff in there. So if I inherited an account from Aunt Sarah, I'm either going to take it and put it into an existing trust account, or I'm going to open a separate account in the name of the trust when I receive that asset. But yes, ongoing funding is important. As I acquire new things, I want to keep it all in the trust.
Just part of your yearly review, you should look through and say, hey, what's changed? If there's a major change or asset switch, then I probably need to make sure that's in the trust or purposely not in the trust, right? Not accidental, just to stay on top of things.
Right. And the trust has benefits that we talk about in other videos, but in the event of your incapacity, everything's in there to be protected for you by a trustee that steps up. And then at your death, you've outlined what happens, and we don't make the mistake of missing a beneficiary or having a joint owner that's not supposed to be on there. It's a whole lot easier to make sure you have a comprehensive plan when we use one estate planning tool and just put everything in there, but does not help you if you've not put anything in there. However, if you didn't put anything in there at all, Chris, what would happen when you died?
Yeah, so let's just say you have an asset that has no way of passing. You had a checking account, savings account, investment account, whatever it is, and there's no payable on death beneficiary, there's no co-owner. Then luckily, when you did your planning at this time, you also considered doing what's called a pour over will. And the pour over will would say, hey, anything I own at the time of my death that doesn't walk on its own, that doesn't have a co-owner, beneficiary, POD, or anything like that, then the executor of my will's duty is to probate the will, gather the assets, pay any taxes, outstanding credit card bills, whatever there may be, pay any debts, and then distribute the remaining balance to the trustee of the trust to be handled pursuant to its terms. So it's not all or nothing. We have a backup plan. You want to have a backup plan because, Kristen, you're driving home today, and heaven forbid you get killed by a drunk driver, and there's a lawsuit for your estate. Where would those funds go?
Right.
I mean, there's other acquired assets that you can't predict today, and you may never have the ability to put into the trust, and that's why you also have the pour over will.
Right. So you do always still have a will. Even if you have a trust, often folks say, oh, well, I don't need a will. Yeah. Yes, you do. You have a trust, but you have a belt and suspenders part of the plan. So if something is missed or something happens or there's just, an unusual situation, you have an outstanding last paycheck, you have a property tax check coming because your roof was damaged. There are lots of reasons that come up that you might need an estate that we just can't foresee because it's just life happening at the time. So you have a trust fully funded. You still have a will that can get probated in the event that something is messed up or is just
forgotten.
Yes. Life happens, but you need both. So if you do have that trust, this is not something that you can do yourself. It really is not. So a trust needs to be done with an attorney that specializes in that, and make sure that it's funded correctly. So it is not just the trust. You have talked to the attorney about making sure that it's funded. You've gotten everything in there that needs to be in there. And then you also have a pour over will that can help you in the event that life happens. That will needs to be probated, but it is still more private and still limited to the asset that needs to be moved to the trust. So still great benefits, but do have all those things in place. Anything else you want to add?
No, that's good though. I mean, the follow through is very important on these
Right.
trusts.
Right. Yes. But anyway, thank you so much for joining us. We'll see you next time.
Bye, y'all.